We start the meeting. Some new information has come to light, and there may be consequences for the agenda tonight. And we are talking at the moment between the officers and our legal advisor. So I must ask for your indulgence for a few moments, please. So going back to my teacher role, talk among yourselves for a bit, please. Well, ladies and gentlemen, I think we've reasonably in a position to start now. It's been quite exciting, it's a day of exciting meetings. Well, welcome to the October meeting of the Borough Council's Planning Committee. I'm Councillor David Jones. I represent the West Highcliffe Ward and I am the chairman of the committee. Now, members and officers do have their names in front of them, but I do know that the camera doesn't always pick them up. So I'd be grateful if members and officers present could introduce themselves briefly, starting with Councillor Abbott.
Janet Abbott, Grange Ward.
Denise Jones, Grange Ward.
Peter Hall, Town Centre.
Daniel Rayner, Firehead Democratic Services.
Daniel Lucas, a barrister, non-practicing and the principal planning lawyer.
Linda King, Development Management Manager.
David Hodges, Development Management Team Leader.
Fred Neal, Jumpers Ward, Councillor.
Wendy Grace, Town Centre Councillor.
Vicky Hallam, Highcliffe Ward.
Thank you very much. I'll take a few moments to explain the process that we will be working to this evening. Each application will be presented by the appropriate case officer. And I should say that members have all had detailed planning reports sent to them well in advance of this meeting. After each presentation, those members of the public who have written to the council requesting to speak will be invited to take the seat at the opposite end of the table. The time allocation is 3 minutes for each speaker. In the interests of fairness, this will be strictly timed and enforced. Speeches must relate to material planning issues and must not be derogatory. No questioning is allowed, and no further written information, photographs, plans or other material can be submitted at this stage. Once the members have heard from any public speakers, I will ask members if they have any questions of fact that they wish to ask officers relating to the evidence that they have heard. If there are no further questions from the members, I will seek a motion, either to approve, refuse or defer. Once the motion is proposed and seconded, after debate, it will be voted on, and that vote, except in the very rare circumstances outlined in the council's constitution, that vote is final. If there are any questions, the officers, the vice chairman or myself will be very happy to answer them after the meeting. If the meeting extends beyond 9 p.m, I shall ask for a proposal to extend the meeting to a specific time. Once the item under discussion at that time is resolved, the meeting will then be adjourned and will reconvene on another evening. In order to assist us in the process, I must ask everyone to ensure that mobile phones are either switched off or on silent mode, and we would be grateful if you would remain quiet while the meeting is in progress. I should perhaps say that in Christchurch we have a custom whereby those whose mobile phones ring in the meeting or members whose mobile phones ring in the meeting are invited to donate £10 to the Mayor's charity. I'd like to remind everyone that the meeting will be filmed by the council and broadcast live on the internet and will be capable of repeated viewing. If you are seated in the chamber, it is possible that the cameras will capture your image. By your presence, you are deemed to consent to being filmed and to the use of those images and sound recordings for webcasting and or training purposes. As the chairman of the meeting, I can at my discretion terminate or suspend filming if, in my opinion, continuing to film would prejudice the proceedings of the meeting, or if I consider that continued filming might infringe the rights of any individual or breach any statutory provision. There are a couple of housekeeping items. The facilities are through the door there and into the foyer, and there are no fire alarms scheduled for this evening. So if the fire alarm does ring, I would ask you to vacate the building as quickly as possible, either through the double doors there and out into the foyer and then through the double doors there, or through the double doors there and out into the cold wide world outside. And a small note, I know everybody says that, well, of course the fire alarm won't ring. This is the second time today I have said this, because I'm also chairman of the county's planning committee, and this morning I read something very, very similar out, and just as we were getting to the end of the meeting, the fire alarm rang. So it can happen, and if it does now, well, I've told you what to do, so I'm in the clear. Right, thank you very much. We'll now move on to the agenda proper. And the first item, apologies for absence.
Yes, Chairman, apologies from Councillors Davis, Geary and Jameson.
Thank you very much. I should mention that Councillor Jameson was in hospital recently and is in quite some difficulty. Is it the wish of the committee that I ask the administrator to send our best wishes and hopes for speedy recovery? Thank you. We now move on to the next item, which is declarations of interest. Councillor Hall.
Thank you very much, Mr. Chairman. On 4C, 4D rather, 24 St Margaret's Avenue, that's my application, and I'd like it deferred, please, for further information.
Well, that is noted. If you're the applicant, you're entitled to ask for a deferral. Officers have no objection.
Technically, it should come via your agent, but as you're here, Councillor, I think we'll accept
Thank you very much.
that, yes.
Thank you. Are there any further declarations of interest? Councillor Grace.
I have declaration of interest on 4C, St Anne's Cottage, Salisbury Road, Winton, as the applicant is a personal friend of mine. Thank you.
Thank you. Councillor Jones.
Just to say, Mr Chairman, I do know the applicant vaguely of 4C because we have recently become involved on the same committee, but in no way are we on a friendly basis. Well, I don't mean we're at enmity with each other, but we are. There is no history of friendship between us. Therefore, I think I can approach this matter with an open mind.
That's fine, Councillor Mrs Jones. Councillor Grace, you mentioned you're a friend of the applicant on the declaration you stated. Is that a close acquaintance, so as to say that you're friends
Yes.
in a personal capacity?
Yes, I am.
In that regards, I'll ask you to leave, please, obviously, because of the appearance of bias and predetermination.
Yes.
Thank you.
Thank you.
And on this matter, on the same application, I too know the applicant, who is a member of the Burton and Grange Conservative Committee, but again, like Councillor Mrs Jones, there's only a very limited degree of social interaction, and I do not consider that this affects my ability to approach this matter with an open mind. I will make one further statement on this. Members and members of the public may have noticed that I call this application in, and normally it is the responsibility of a ward councillor to call the matter in, and you do not call in applications from a neighbouring ward, although it is constitutionally possible to do so. It is not regarded as good practice. However, I was contacted by Councillor Jameson by telephone on the day that the call-in closed. He had intended to call the matter in. He wasn't able to contact the planning committee to send in the call-in email. He asked me if I would be prepared to call the matter in as the county councillor, because it is in my county council division. So I agreed. I sent the email at 22 minutes past 5, and it was very fortunate that the officers were there, because technically we were out of time because it should have shut at 5:15. But in doing so, in writing the email, I inadvertently may have given the impression that I had prejudged the matter. What I should have said is, on the basis of the evidence I had seen from the applicant, because she had sent me some information, I believed that there was a, if you like, a case to answer, that there, on the basis of that evidence, but I had not seen the officer's response to that. I should have made that clear, but I do confirm that I approached the matter with an open mind, and I am of the opinion that I have not prejudged this matter in any way. Is that sufficient?
I think it's a sufficient enough explanation, Chair. Thank you.
Thank you. So now we move on to is there any other declarations? So I'm sorry about that rather long preamble. Minutes, do I see a proposal of the minutes? Councillor Neil, seconded. Councillor Mr. Jones. Is it your wish that I sign these minutes as a true and correct record of proceedings? Thank you very much. It's approved. Now, when I have been chairman before, I have said that we will take matters on the items in the order in which they appear on the agenda. Having said that, the item St Anne's Cottage, there has been a new development which may mean that we will not be discussing this tonight, and I would ask the officers and the legal advisor to make the appropriate explanation.
Thank you, Chairman. Good evening, ladies and gentlemen, members. This afternoon we received further information. This is set out for members on their update sheet, but for members of the public, this afternoon we received further information from the agent and the applicant, advising that they had photographic evidence to demonstrate that the boundary wall postdates the listing of the property. That has a bearing on the listed building application before you tonight. This has come very late in the day to officers. We feel that we need to do some more investigation because the photograph is not very clear, and I understand, talking to the applicant's agent this evening, that other members of the public may have information that can corroborate or not some of the information that is being claimed. And I think, for fairness to the applicant and fairness to committee, we need the full information before us this evening, or before we can make a recommendation to you and before you can make a decision on this application. And I'm therefore recommending that that item be deferred, the two items, the planning application and the listed building application for St Anne's Cottage, be deferred from committee tonight. We would recommend that the application comes back to you in the December meeting rather than the next meeting, due to the circumstances of the agent who won't be available at the next meeting, and it's only fair that she is here again to present her client's case. So we're recommending to you that, in light of this information and the uncertainty surrounding it at the moment, that the items be deferred until the December meeting.
On this point, I understand an enforcement notice has been issued. Am I correct that it is the officer's intention, if deferral is agreed, that this enforcement notice be withdrawn? And should the committee be minded to refuse when the matter comes back to us, then the committee will be asked to authorise a issue of a new enforcement notice.
That's correct, Chairman.
Members, it is a difficult decision because I know that the applicant is here, and obviously there is a lot of local interest in this. But the officers have said that they need to look at the evidence and to test that evidence to make sure it is sound. If we were to proceed, we would have to make a decision on the evidence before us, and I think the officers would say that it would be unsafe to rely on this photograph until it's, we'd say in historical terms, unless its provenance could be proved. But it must be now up to members to decide how to deal with this application. And the correct way, I think, subject to any revision from my left here, would be for a member to propose whether or not stop gibbering and start again. If a member were minded to propose deferral, then that matter would then be deferred to the December committee. But I am in the hands of members. Councillor Neal.
I'm happy to defer that.
So there's a proposal for deferral. Is that seconded? That is seconded.
No, I'm not seconding it, Chairman. All I'd like to say, first of all, I think we should have got on with the job and get it finished. It's been that they've had this some time, and we should have got that information earlier. Secondly, I didn't realise that, and I'd like to know when, has this committee decided on enforcement action?
I can deal with the second of those points. Sometime in the intervening period, the power of this committee to revoke enforcement decisions to itself was removed by a change to the Constitution. Now, were we continuing as an authority, I would certainly be seeking to have that change in the Constitution reversed, because to my mind, it is, if we are a member-led council, members should have the right to know what and to take action on enforcement, whether or not something is enforced as that shouldn't be or should be enforced and isn't. This was the case throughout my first 10 years in this chair, and as I said, it has been changed. However, we only have a matter of some 5 meetings left before we are kicked into the outer darkness or Bournemouth, whichever way you look at it, and it would be difficult and probably pointless to reverse that now. So that's why the committee has not been asked. But in this instance, should the application be refused at its next meeting, then I am assured by the officers that any decision to take enforcement action would not be done under delegated powers, but would be referred to this committee. So I hope that assures you on that.
Thank you very much, Chairman. You have reassured me. Thank you.
Thank you. So I have a proposal for deferral. Is this seconded? Councillor Hallam?
I'm very happy to second that. I don't feel we've got sufficient information before us.
Councillor Grace, although we're not in the substantive debate, can I ask the officer, should Councillor Grace have withdrawn?
Yeah, obviously it's not on the merits at the moment, it's just on the issue of deferral. So, yeah, So yeah, please do recuse yourself.
Thank you. It is proposed and seconded for deferral. Is there any debate? All those in favour, please show. Against? And abstentions. That is deferred until December. Apologies to the applicant, but we have to make sure that the matter is dealt with soundly, and we must not leave ourselves open to legal challenge. Okay. Thank you. So we now move on to the next item, which is the... So, yeah, can somebody tell... and should any member of the public have been here just for that application would now like to leave, please do so. As I said, apologies, but we have to be very, very careful in planning. Okay, so now we move on to the second item on the agenda, which is A, 23B Dudmore Farm Road. Okay, and it's Mrs. King.
Hello again. This is an application at 23B Dudmore Farm Road in Christchurch to vary conditions 1 and 2 of a 2009 planning permission to allow the permanent change of use of land for the stationing of a static caravan and touring caravan for a gypsy family. You'll see the application site is in the Dudmore Farm area. I'm sure members know where that is. It's accessed off a track of Fairmile. There's a scatter of residential properties, caravans, and a variety of uses in that location. This is the application site itself. It's a very regular shaped site adjacent to other properties. Just provide you with an aerial photograph to show it in its context with Town Common, which, as members will know, is an SSSI and also is part of the protected Dorset Heathlands, and that is an issue that is of importance in the determination of this application. This is an aerial photograph of the site as it was in 2014. The applicants at that time had a touring caravan on the site. It is an incredibly tidy site. This is as it is at the moment. This is the static caravan that the applicant and his wife live in. This is their bathroom facility, and it is, as you say, very tidy, very well maintained, well screened property. It has a small dog pen and it has a small parking area. It has gates, secure gates, and it is a secure site. So if we go back to the aerial photograph, and this is the SSSI boundary in this location. The application is before you tonight because we have a sustained objection from Natural England to this application, and under the terms of your constitution, any application where there is an objection from a statutory undertaker, where the authority or where your officers wish to come to a recommendation that is contrary to that, comes before you for determination. Now this site has, as you can see from the site history, a long planning history. Planning permission was granted on appeal to the applicants in 2007 on the grounds of special circumstances of the applicant's needs to stay and reside in this location. At that time, Natural England gave advice at the inquiry and didn't object to temporary consent on this site because of the needs of the applicant, and also the intention that there will be a Dorset-wide Gypsy and Traveller Development Plan document which would assign sites for the Gypsy community and the travelling community as required by legislation relatively quickly. That was in 2007. As members are probably aware, that DPD has yet to be completed. There is still an issue of outstanding need for sites in accordance with the requirements set out in legislation to find sites for our Gypsy and travelling community. There are pitches on Dubmore occupied by Gypsy families at the moment. This site has been occupied since 2006, temporary consent in 2007, and we've given a series of temporary planning permissions since that date. The last temporary consent actually would expire in September 2020. So that shows that the applicants have resided and can reside on that site for a significant length of time. But I think they rightly now decided that they've had a series of temporary consents. It doesn't give them any certainty. They still have needs to live in the area, and they would like now the planning permission to be granted to them on a permanent basis. They don't have to keep renewing their consents, and they don't have the uncertainty as to whether they can reside on this site. You will see from your report let's just get to the right pages, in the section on the National Planning Policy Framework on page 15, that there is a planning policy for traveller sites document that sets out how travellers' housing needs should be assessed and how those need to be addressed in development plan documents, that we should have a 5-year supply of deliverable sites for travellers, as well as a 5-year supply of deliverable sites for the settled population. We don't have a 5-year supply at the moment. We have no sites allocated within the borough at all, so there is a justification on that basis for the need for the applicants. We have the objection from Natural England is set out in detail in paragraph 7.1 to 7.4 in your report. You will see from that report that that Natural England have made reference to an appeal decision in White Lodge, Verwood Road, and that's in Three-Legged Cross, that's in East Dorset, where an inspector in that location, and again we refer to this decision later on in our statement at 8:21, thank you David, because that is a very critical appeal decision. In that case, the occupants of the site in Three-Legged Cross, Verwood Road, had occupied the site prior to the definition, or prior to the introduction of the interim planning framework, which came into effect in 2007. You will note the applicants had been living on this site since 2006. The appeal inspector with Natural England concluded that as the site in Verwood Road, Three-Legged Cross, had been occupied prior to the introduction of the interim planning framework, then that was an existing household, an existing property, and didn't have a bearing on the attempts in the interim planning framework to prevent any further residential development within 400 metres of heathland. The current application site before you is within about 200 metres of heathland, so it falls within that definition. Now, Natural England have tried to differentiate between the appeal case in Three-Legged Cross with the current application before you, and have tried to put weight on the fact that the appeal site had been occupied since about 2003, and there had been sporadic occupation of the site since the 1990s. But the inspector, if you look in your in the agenda in 8:21, does not really make that differentiation. 8:21, so we've got Natural England's position here would appear to be that whether the occupation of the site was well before the introduction of the 400-metre embargo, or even the designation that the site should be material. However, this was not the inspector's reasoning in the White Lodge decision. Here the inspector concludes that, whilst the use of the appeal site has not been lawful, it has nevertheless been in existence continually since 2003 and periodically from as early as 1992. Thus, if permission were to be granted for the use to continue, there would in real terms be no actual increase in the number of existing households within the 400-metre protection zone, nor any actual increase since the 400-metre consultation zone was established in 2006. Now we're suggesting to you tonight that that's the same situation as the applicant before you. It was in occupation in 2006, and the protection zone was established later on in 2006, and the document was actually formalised in 2007. So we feel that Natural England's argument in this instance doesn't tie up with an appeal decision that has already been granted and considered this very issue elsewhere within the South East Dorset Heathlands area. And here again the applicant is asking for the continuation of the personal consent, and that was a consideration that the appealed inspector in the Verwood Road case came to, that he granted again a personal consent for the then applicant and their dependents, and felt that he was addressing the situation that existed at the time prior to the designation of the interim planning framework, and that again is the case before you this evening. So in terms of Natural England's objection to this proposal, we feel that they have misinterpreted the inspector's recommendation and decision on the previous case, and we've asked them to differentiate between the two, and they just say the considerations are different. We haven't actually got a reason as to how they are different. We think they are very similar. So we think that the applicant isn't, the continued occupation of this site isn't contrary to the interim planning framework and policy ME1 and ME2 of the All Call strategy, in that they pre-exist that limitation. The site also lies within the Greenbelt, and as you're aware, residential development in the Greenbelt is inappropriate, and therefore we are looking at whether there are very special circumstances that would outweigh the harm to the Greenbelt in this situation. The site, as we say, has been in existence and has been occupied since 2006, and temporary planning permissions have been granted since that date. That is one consideration. We have the issue here is that there is a need to accommodate Gypsy and Traveller families in the area, within the locality, and those that have local connections. There is set out, again, just turn to the right part, in the Greenbelt, if you are looking at paragraph 8.06, the government guidance on traveller sites advises local authorities that they should consider the following as part of their assessed Gypsy and Traveller site proposals: the existing level of local provision and need for sites. We have no local provision, and there is a recognised need that has been established through the Gypsy and Traveller Accommodation Assessment 2017. The availability or lack of alternative accommodation for the applicants. Well, there is no alternative accommodation within the locality. Personal circumstances of the applicant. Well, there are specific reasons why the applicants need to reside on this site. That locally specific criteria are used to guide the allocation in plans. We're still working, the policy teams are still working on the development plan document. It has not progressed as far as it would like to have done, so you have no allocated sites, and they should determine applications from site for any traveller and not just those with local connections. Well, actually here you do have people with a local connection, so that's not a main criteria. What we feel here, and your planning policy manager concurs, is that any site for travellers within Christchurch Borough are likely to be in the Greenbelt. all the work that's been done on the development plan document has not come up with any sites that are suitable for this use other than greenbelt sites. There is an established need for a site within the locality that it's been established through the work in the Gypsy and Traveller Accommodation Assessment. The applicants have been on site since 2006. Their personal circumstances are still the same, and we feel that there are very special circumstances in this case, in Greenbelt terms, that the allocation or the identification of this site as a site for the applicants for their personal use on a permanent basis is an acceptable use within the Greenbelt, as it would effectively be the allocation of one of the sites that will be sought through the development plan document anyway. And on that basis, and on the basis I've set out in terms of the Natural England comments, recommend the application to you for approval.
Thank you very much. This is obviously a very complicated and complex case, and I am reminded of the saying, hard cases make bad law, because we have two very conflicting priorities. One is to protect the green belt, and one is to look after the needs of an individual. And in trying to reconcile these two objectives, we are facing obviously some difficulties. Questions for the officers, please? Councillor Hall.
Thank you very much, Chairman. I think we've got a lot of sensible conditions down by the officers. All I would like to ask is, how often are these checked to ensure that all these sensible conditions are complied with? Because obviously it's all right putting conditions on, and I think they're very good, but I'd like to know how often they're checked, please.
They're not checked systematically, but these are the same conditions that were imposed by the planning inspector in the 2007 appeal decision, and we have had regular contact with the applicant over the years, and to date have found no breaches of planning control other on the site at all in terms of any of the conditions.
Thank you very much. That's very reassuring, Chairman.
Thank you, Chairman. I just really wanted to understand one of the conditions in terms of weight, where it's got here no vehicle over 3.5 tonnes should be stationed, parked or stored on the site. Can you just give me an example of sort of the size of that? Was that sort of a static caravan sort of size, or?
It's about a Luton van size, box van size vehicle.
Okay.
So that the applicant, as you probably noticed from the photographs, is sometimes a small flatbed truck on the site, and sometimes a small van.
Okay, so nothing more than a caravan sort of weight wouldn't be allowed on the site.
So it's small scale vehicles for work purposes, but not heavy vehicles.
Perfect. Thank you.
Thank you. That was a very comprehensive report. But could I just ask regarding section 9, the second section, where it says the use hereby permitted shall be carried on only by John Gaskin and B. Gaskin and their resident dependents. Could I just ask, are we referring to actual resident dependents now?
It could be resident dependents in the future. That is the same condition was imposed by the planning inspector in 2007, and it's the same wording of the condition imposed by the planning inspector in the East Dorset case. So that is a fairly standard personal consent type condition, because it is to the applicants themselves and any resident dependents they have at the moment or could have in the near future.
To come back on that, is there any way which this could be rephrased? Because you could have a situation whereby Mr. and Mrs. Gaskin have nobody here, but would this mean, say, a niece or a nephew could come and say, I am their dependent? Or are we talking about their children? A bit vague.
I think I can see where you're driving, Councillor Mrs. Jones. You have to bear in mind, effectively, the rights of the individuals here. So it could well be, for example, familial members may come into the family and you wouldn't want to take away that right. It's a basic human right. The right to a family, the right to respect private and family correspondence, Article 8. For example, you wouldn't want to take away their rights to foster. And you wouldn't ordinarily expect such a condition on normal dwellings in the Green Belt. So it's a question of fact and degree and weighing up proportionally where you draw the line. And as Mrs. King to the left of me has already mentioned, these are standard inspectorate conditions. So one, I would caution and hazard against fettering these because they're model form of conditions used nationally. And secondly, given what I've said previously, you wouldn't want to fetter basic human rights, the right to foster, the right to provide familial accommodation in times of need or family crisis. So I urge strong caution because you're straying into territory where there could be a degree of prejudice in the sense of there being some form of inequality if you go too far. So I think with the best will in the world, I can see where you're driving, but bear in mind what I've mentioned in terms of proportionality and fettering basic human rights and needs.
Might say so. I'm not looking at the lifestyle of Mr. and Mrs. Gaskin. I'm just thinking of cases within my own ward where housing associations have been a little bit selective as regarding dependents and whether they had a right to stay there.
If I may come in at this point, this is where our friend the curious comma would have been useful. Does this mean the site should be occupied by John Gaskin and B. Gaskin and their resident dependents? Does it mean this site should be occupied by either John Gaskin or Mrs. Gaskin or their dependents? What I am concerned about is, are we granting through this condition, and I have every sympathy with Mr. and Mrs. Gaskin, and I do feel that it is right for us to give them some certainty, and I would hope that we can make this consent. But what, for example, would stop a 20-year-old dependent or a young dependent coming in and saying, well, I was their dependent, I've come to look after Mr. and Mrs. Gaskin, and then when I'm left here by myself, I've got the right to stay here because I was a resident dependent at the time that this planning permission was given. It's slightly woolly phrasing, and if I may be forgiven for saying so, I know this is the sort of phrasing that tends to lead to disagreements between lawyers and arguing over commas and such like. But we want to get the objective, I think that we would all agree, is we want to give Mr. and Mrs. Gaskin certainty and security. But the conditions envisage that when it's no longer needed, the site will be restored. But it's this resident dependence that does tend to worry me slightly. And I wonder, are we sure that this will have the effect that we hope it will, in that when Mr. and Mrs. Gaskin cease to need the site will then be restored and as set down in the other conditions? It's just this little, it's this little bit of looseness that worries me, and I wonder if the legal advisor can enlighten me, can expand on this a little.
Yes, thank you, Chair. So take the starting point, condition 1. So condition 2 should be read in context with condition 1. So from the outset, anyone that is actually going to be residing there shall not be occupied by any persons other than gypsies and travellers. So resident dependents would also have to meet that criteria. So they could well be familial members from the settled community. That would preclude such members under condition 1 being a resident dependent because of condition 1. They're not meeting the planning policy definition of a gypsy or traveller. I think that's the first point. So they have to be read in context, not just in isolation, taking condition 2 out of the context within which this permission is going to be granted. So condition 1 and condition 2 bite together in the sense that you've got to be a gypsy and traveller under the necessary planning legislation, planning policy documents. Condition 2 then comes into play. The problem I've got is Mr. and Mrs. Gaskin grow old. Someone younger from the gypsy traveller community, a family member, may need to live there to nurse and care. You wouldn't want, I think, a situation wherein which a live-in carer from the gypsy and traveller community, and indeed a familial member, caring for and nursing Mr. and Mrs. Gaskin, to be excluded. It would be a folly, because you're essentially setting up Mr. and Mrs. Gaskin to be in a position where they're going to be in breach of a condition and liable to a notice and prosecution. So with the best will in the world, it's very difficult to come up with a set of conditions which are going to appease every single party. I can see the concerns raised by members, of course, but condition 1, condition 2, and also condition 5. If we look at condition 5, the residential use hereby permitted shall be for the stationing and occupation of no more than 2 caravans as defined by the Act. The site shall be laid out in accordance with the layout agreed with the local planning authority as part of the planning application. So you have control over the built form as to what can come forward. So conditions 1 and 2 control the user, the manner of the use and the extent of the use. Condition 5 deals with the built form and what can actually now exist and what can't exist. So to all intents and purposes, I think we are where we are. Members obviously are at liberty to amend conditions upon the necessary resolution and vote, and we can guide you as we see fit. But I think in fairness, they are model conditions. We've done the best we can, and one would hope, given that this is a context of where there has been no breaches by the Gaskins, that perhaps the concerns are unwarranted, given the perpetual temporary uses and compliance by Mr. and Mrs. Gaskin. Is the concern perhaps a little bit unjustified, is what I would say? Is it a proportionate response, given a chronology of diligent use? So I leave it as that. It's for members obviously to amend it. It is for the committee, and we can necessarily advise if needs be. But that's as far as I can probably go in giving the steer.
If I can come back on this. Look, as it states, it says, when the land ceases to be occupied by John Gaskin and B. Gaskin and their dependents, resident dependents. Now that lumps everybody together. If there were, I wouldn't want it ever to be said by somebody in the future, Mr. Gaskin is no longer there, so it's B. Gaskin and their resident dependents, if any. And therefore, that's it, because it's not be occupied by John and B. Gaskin. So what I'm just looking for is that Is there any way of wording this to make it quite clear that it is John Gaskin has the right, Mrs. Gaskin has the right, and any resident dependent has the right, but should that resident dependent cease to be a dependent of them, the right lapses? So that they both can, the certainty that they both can occupy that for as long as either of them needs it, but that once they cease to need it, the right for the dependent lapses. That's what I'm trying to get at.
Yeah.
And I mean, are we able under the present setup to say, yes, we agree this, but we leave this condition to be agreed by the officers and the chairman? The exact wording.
I hear what you're saying, Chair. Bear with me. Miss King wants a quick.
There will be
Right,
a
Mike.
very short intermission, so if anybody feels the need either to go and get a cup of coffee or for anything else, we'll adjourn for a couple of minutes. Right, ladies and gentlemen, I think we're back in business. I am assured by the officer that this condition would never be so interpreted as to require that both the Gaskins must be in residence at the same time, so that the permission applies to each person individually, and also any resident dependent, while they are dependent, while they're resident, but it wouldn't be passed on, I think, is it? Yeah. So with that clarification, ladies and gentlemen, I think we are able now to go into debate, unless there are any further questions. Councillor Hall.
No, I think going into debate. I'll put my hand up for
Yeah.
debate, Chairman. That's what you
Yeah,
said.
Councillor Mrs Jones, are you debate or
For debate.
debate? Okay, I think Councillor Neil is the nearest ward councillor.
Oh, it's the butting up wall, if you like, yes.
Yeah.
But I'm quite happy.
Right, Councillor Hall.
Thank you. Thank you very much, Chairman. I thought when you put your hand up first, you got first choice. What I was going to say is, I think this is a very comprehensive report, and I think the officers have done a really good job on that, and also with the conditions. And what is very clear, I've been past the site quite a few times, it's always kept well managed, and it is always a very clean site. So I don't think we've got any fears there, Chairman. So I'd like to propose as set out by the officers.
Is it Councillor Mrs Jones? It's proposed and seconded as set out. Is there any debate? As there is no debate, we'll move straight to the vote. All those in favour, and I shall vote. That is unanimous. Thank you very much. So we now move on to the land at West Hayes, Burley Road, Winkton, and who's starring on this one? Mr.
Hodges.
Mr. Hodges.
Thank you, Chairman. I'll just get to the start of the presentation. So, Chairman, members, this is an application for the development of this land to the rear of West Hayes in Winkton for 4 detached dwellings with access and on-site parking. The site is here, so this is the main Salisbury Road through Winkton and then the Burley Road here. This is the property West Hayes and the land here, and members may be familiar with the redevelopment of the former school site to the south there. This is your site location plan, the red line plan, showing the property fronting the Burley Road and the land to the rear. An aerial photo to help you with some of your orientation and particularly with some of the pictures of trees that you'll see later, and the relationship with, my cursor's disappeared, it's come back, relationship with existing properties along Burley Road here and to the south along the former school site. Just for members' benefit, this just helped you clarify the current greenbelt boundary affecting washing over the entire settlement here, and then on the right hand side the boundary of the conservation area. This is the existing layout of the site, where you've got the dwelling to the north and the land to the south. And as set out, Chairman, the proposal is for these 4 dwellings, so you would access from this existing gap between West Hayes and the property to the west, which is called Brockett. Access here, so you've got room, if you can see, members, for 2 vehicles to pass at the front of the site. You've got a narrow part here where it would be single vehicle width, and an area to pass here. And then your 4 dwellings arranged within the site, and you can see the parking and integral garages and turning available for the properties. All of the 4 proposed dwellings are single storey, and here is their proposed layout, and you can see the integral garages with, included. Just to skip through the elevations of 4 properties, so on each one you have Unit 1, Unit 2, Unit 3, Unit 4 on their elevations, so north and south, so west and east for 2 and 3, and then 3 and 4. So you can see the similarity in the proposed designs of the properties. Here's an axiometric view for you, just to show that relationship. Burley Road on here, access into the site here, and the 4 proposed dwellings. This shows you the trees on site to be retained and protected there in this area here, and along on the southern boundary of the site. And this shows you how the application intends to protect the trees during the course of construction, and then their subsequent relationship to the proposed layout where the particular gardens that the trees will sit in should the development go ahead. Just to take you through some photos of the site. So here on the top left is your access in. So this is West Hayes, and then Brocket to the right hand side, and you've got the garage to the front of West Hayes. This is actually in the site looking back up towards the Burley Road, and the access would come along this part here in between the two properties. And here's a view from the rear garden of West Hayes, looking towards the neighbour to the west. This is looking into the main body of the site, looking back up north towards West Hayes and Brocket. So the boundary of the site with the neighbouring property, you can see this green hedge here. This is looking into the far corner of the site. This is looking down into the southwest corner, and again you can see the well-established boundaries, hedges and trees that are on the site. And this is looking back. You can just see here some of the newer properties built on the former school site. And just to clarify some of the pictures of the trees, so this is the clump of trees that you saw in the tree protection plan, and again a view down towards the back boundary, the southern boundary, where you can see the mature trees and hedges on the side. I'll go back to the action lecture, that's quite helpful. So Chairman, as it stands today, the application lies within the green belts. There's no village boundary for Winkton. It's not a settlement identified in the local plan for development. So applying the policies in the local plan, we regard this as a largely unsustainable location for further development. And in effect, we have identified land for additional housing in more sustainable locations within the urban area. In addition, it lies within the green belt, so the development of the site is inappropriate development as set out in the report. And whilst the in addition to the site being residential development, the site being inappropriate development, we also consider that it would adversely impact on the openness of the site, and in particular by the development of the site would inevitably, for our point of view, reduce the openness of the site, replacing an undeveloped site with bricks and mortar and surfacing. We also consider, as you'll see set out in the report and following on from your conservation officer's comments, consider that this would adversely impact on the conservation area. The conservation area appraisal identifies a transition between the historic core of this village centre in here to a more semi-rural character as we go out onto the edge of the conservation area. And this open area of land forms part of that broader character, transitioning from this historic village core out into the countryside. Along with that, we consider that the proposed design of the dwellings would be more appropriate for maybe a more suburban location rather than this historic village core where it would join, and we would look for residential development to reflect more closely the historic core of the village if it was going to take place on the site. We also have reservations, as you'll see in the report, about the relationship of how the access will work. So looking at how this will work in terms of the number of properties that would use the access and the noise and disturbance would likely result, and the very narrow proximity to the two dwellings, the narrow gap for that many properties to be served from that particular access point. And we feel that that nature of that noise and disturbance would be detrimental to the living conditions of those properties. Finally, as you'll see, as a recommendation for refusal, you'll see our concern reflected in the tree officer's comments about the possible prejudicial impacts on the long-term retention of these trees, both during the development phase, but also if the development were to go ahead, the fact that particularly these trees would heavily overshadow both these properties and their gardens, and would likely lead, in your tree officer's opinion, to a pressure to fell long term. And of course, the long-term loss of the trees for us would be again a negative impact on the character of the area and the conservation area. Just to clarify, a final point about reason for refusal number 5 is that we would need to add in policies ME1 and ME2 to that reason for refusal to pick up the policy basis. So, Chair, you'll see from the report we have a number of concerns, a number of reasons for refusal, and on that basis, the application is recommended for refusal, Chairman. Oh, pardon, and thank you. Just to confirm, the additional informative notes to be added in the event of a refusal of the permission, that the applicant can deal with reason for refusal number 5 through the completion of a suitable Section 106 legal agreement to make the heathland contribution. Also, that should the application be allowed at appeal, then the development is still forced to be make a civil contribution, and also just to confirm the plans are to be refused. But just to confirm, Chairman, the recommendation to refuse application.
Thank you, Mr. Hodges, and thank you for deferring to one of my little foibles. We have Mr. Howells, who is agent for the applicant. Mr. Howells, if you'd like to come to the, which you are doing, I'm afraid the magic device which times you and shows pretty lights is sitting in East Dorset, so we have to rely on the committee administrator's phone, but I can assure you, you will have 3 minutes, but you won't have a warning. Thank you.
Thank you, Chairman. Good evening. As you have heard, this site is defined as being within the green belt. However, the land itself is and has been for many years been used as part of the residential curtilage of a bungalow and not a historic field as quoted. The application site is surrounded on all sides by existing residential development. The historic core is located to the west. Older detached houses to the north and east, and to the south, some 20 houses positioned in Homefield Close, which itself was justified as a special circumstance in Greenbelt. Paragraph 145 of the MPPF states that limited infilling of urban settlements is justified within land covered by Greenbelt Close. The application site is not visible from any public viewpoint, so how can it be in the public's interest to retain it as Greenbelt or protect its openness? Planning inspectors often take the approach that whilst a proposal may constitute inappropriate development in the Greenbelt, if the proposal does not contravene any of the 5 purposes of Greenbelt policy, then the proposed development has been allowed. In this case, I would opine the following. The scheme represents an infill development that does not cause an unrestricted sprawl, will have no impact to neighbouring towns merging or affect their character. The countryside will remain unaffected, but the proposal will utilise urban land. The purpose of a conservation area is to protect an area's character, not to prejudice development further. The proposal will have no harm to the historic core due to the fact that the site is not visible from the public domain. The proposed bungalows will respect the local distinctiveness in terms of design materials and offers a spacious environment which accords with the prevailing pattern of development. The bungalows will be positioned outside the root protection areas of important trees. Window positions have been taken full account of in respect of tree canopies, so lounge and kitchen windows will benefit from good natural light. The highway officer actually supports the proposal, but the planning officer has suggested that vehicle movements will cause noise disturbance to neighbouring occupiers. This scheme will not generate significant vehicle movement, and now that the neighbouring occupiers that are alleged to be affected actually support the proposed development. Acoustic fencing could be conditioned if the planning authority were minded to approve the scheme. You will note that representation from the community is balanced, and since my client undertook negotiations with the landowners, many of the initial concerns that have been raised have been addressed. The land has already been identified in an emerging policy document as a potential housing site, so the council has already nodded towards the principle. This application merely seeks to bring that principle forward to delivery. I would ask members to approve the proposal, as there are special circumstances that justify the proposed development in the Greenbelt and the conservation area. If members are uncertain, I would request you to defer the decision so you can undertake a planning committee site visit to witness the urban context yourself. Thank you, Chairman.
Are there any questions to the officers on the information that we've heard? Thank you very much.
Mr. Chairman, what I would like to ask is, because it does seem a massive long drive, I'd like to know what the length is and also the width of it, please. Is that possible?
Can I just reiterate a point that I have made many times over the past 13 and a bit years? If members need to know measurements, it's always helpful if the officers can be asked in advance, then they're not desperately trying to find things beforehand. So if members do have any queries about factual details like this, which can be determined, I know that there will always be matters that will come up in debate, but if members can please assist the officers and ask their questions where it's obvious first.
Well, I'd like to reply to that, Chairman. I think sometimes it could be easy to put these dimensions on the drawing so we can clearly see what the situation is.
That is a matter of process, but I will gladly take that matter up with the officers.
Chair, so the length of the driveway from, if I just indicate, if I got the right mouse, from the Burley Road boundary, yep, down to this point here is 50 metres. Yeah. And my understanding, from my memory, it's 2.9 metres at the narrowest point. 2.9.
Thank you again. So that's about 170 foot by 3'6".
I'm just looking at the single track there on the driveway and how close it is to the buildings. And I'm just wondering, you were going to put a fence or something up there, soundproofing fence? And how big would that be? Because it seems really, really close to those houses to have a huge fence at the side of them. Do they have windows there? Is there a living room there? Bedrooms?
Chairman, this layout plan doesn't indicate an acoustic fence. If, for your benefit, members, the photographs that you have here, let me just find the right one. So this is the side elevation of West Hayes. So there's some windows on there, and then this is the garage at Rocket in the neighbouring property. So it's openings on here, and then the access point would be through this area here.
Just continuing with the fence question. If there is acoustic fencing put up, sorry if you've answered it, but I didn't quite understand. Presumably then that would have to go up along the house on the right hand side where you've got a window. And that would then therefore narrow the driveway even further.
Potentially, I mean, if that was deemed necessary, but I think you would start to get to an issue with the actual physical width for a vehicle to get through at that point. So I would suggest that's unlikely to be practical in the particular circumstances for that side. And of course, the applicant wouldn't have the right to install a fence on land outside of the application side.
Thank you.
Yes. Councillor Abbott, yeah.
But further to the fence and the noise, there's also the exhaust fumes with at least 8 cars plus service vehicles going up and down outside these windows.
Chair, I think the short answer is that's not part of the proposal before you. If there was a solution that was desired that could be imposed by a condition and was within the application site, i.e. it was within control of the applicant, you could consider that. I don't see how you would be able to address an issue of fumes, exhaust fumes, because of the proximity. So the short answer is, if the proposal is to retain West Hayes in situ, in effect you have got that distance that you can see in the right hand photo there between the side of West Hayes and the boundary of the adjacent property. So short of securing more land or a revised proposal, which isn't before you, to do something to West Hayes itself, I don't think we can move that particular issue further forward, Chairman.
Sorry. Is there any consideration for the refuge bins for collection? Because that's quite a long drive that 4 bungalows have got to move bins down, because they won't get a refuge lorry up, will they?
Chairman, again, my understanding from this plan is it doesn't indicate any areas for refuse collection leaving out on bin day. That is something they would need to address as part of the proposals, but it would be something that you could reasonably deal with as a condition if you felt the scheme was otherwise acceptable, I think, Chairman.
Could we go back the screen to the line drawing? No, that's one. It doesn't actually show, as it does in my book, the houses around.
Got that.
Yeah. Is it going to, because they're very short gardens in the school area, is there likely to be any overlooking or issues that we've overlooked?
Chairman, because the property is a single storey, in effect they're at ground level, all of the accommodation. So they are, it's a relatively level site as well, as you've seen from the photos. So in actual fact, with a suitable boundary treatment, we don't believe there'd be any particular loss of privacy from the development, because in effect everything's at ground level and would look at a 1.8, 6'6" boundary along the lines of the site.
In that case, as we haven't a ward councillor, it is in my county division. So, and as I shall be voting on this application, I'd like to give the committee some indication of my line of thought. I am, of course, very familiar with this particular road, having trudged up and down it for the last 10 years or more. And I do know obviously the area well, and I know the site behind it when it was Homefield School and not Homefield College, I think, as it stays in the report. But most of the building of the new development there actually genuinely is brownfield land, because it was the school's classrooms and sports labs and games hall and such like. So that really was genuinely the sort of development that was in mind when the brownfield priorities were assessed. This isn't brownfield land. If this were looked at as garden grabbing, it's, to use a phrase, would be garden grabbing on a massive scale. I'll pick up on one of the points at the office that was made, saying that, well, if you can't see it, it doesn't matter. Well, any of those of us of the male persuasion who've slid a book under our chair or a plate or something or whatever, when we've been told by our other halves that yes, it does matter, even if you can't see it, it's there. And we have actually looked at, in the past, we have looked at possible developments, and we have said, when it's been, I think, upheld on appeal, that the fact that it is there is in itself an effect on the green belt. More people are using it, more traffic, etc. You can't, nasty things can happen to trees when they're being developed and so on and so forth. So, and I would draw members' attention to paragraph 8.9, where it says there's no certificate of lawful use confirming the use of the site as a garden, or saying that it forms a curtilage to West Hayes. The definition of a curtilage is set out in 8.8, a small area forming part or parcel with the house or building which it contained to which it was attached, and hence the severing of the curtilage. So the argument that this is part of the curtilage of West Hayes does seem to me to be a little fragile. The rest of the land is open and shows little evidence of domestic occupation, and if you look at it on Google Earth, you can see there is very little evidence of domestic occupation. Another point that I would put out deals with the drive, if we could come back to that. Some time ago, either late last year or early this year, we dealt with an application in the Amberwood area with a very similar drive, and we refused it, and that refusal was also upheld, and we refused it on the grounds that we're saying this is going to be detrimental to this sort of drive would be detrimental to the amenities of the neighbours. And it is also suggested that well, it's going to be taken out of the green belt anyway, so it doesn't really matter. Let's just get on with it. Well, two and a bit years ago, this country said we wanted to be out of the European Union, and we're still there. And it looks like we're going to be there for a bit. So the fact that somebody says, well, in the future we'd like this to happen, does not mean that it's going to happen. You can't rely on what might happen. At the moment, you can give very little weight to the emerging planning policy document because it's not been out to consultation properly, it's not come back, it's not been reviewed by the council, it's not been submitted. And I think, and I hope the officer will later confirm that you can only give very limited weight to the emerging document at this stage. So really it seems to me that there are that the arguments that there are, first of all, that there are special circumstances. Remember, again, the officer will correct me if I'm wrong, if it is in the green belt, and that is while it is in the green belt, there must be very special circumstances before development is allowed in the green belt. And I don't think the applicant has shown that there are very special circumstances. The application, if it is based on the fact that it's going to be removed from the green belt, is premature. I have my very considerable doubts over the fallback, because it does seem to me that if these 4 outhouses or dwellings or whatever were to be developed, I think there might be enforcement concerns there. But again, that is something, it's not, I think, a fallback position that we should consider. So, members, I've looked at this and I do understand, yes, we do need new homes. Yes, I do understand that the reason that we have planning is to show that, to let us shape the development, if you like, in the interests of all, but to allow, as far as possible, an individual to do as he wishes with his own property. But we are in this position where we are looking at something that is very, very fundamental. The green belt is still the green belt. Who knows what will happen to it? We cannot base a decision tonight on what might happen in a year's time. So if a proposal came forward to refuse as set out, I would be inclined to vote for it. Councillor Hall.
Thank you very much, Mr. Chairman. I'm very thankful for your words of wisdom. I can't quite see how Brexit fits in with the planning, but nevertheless...
it's not coming yet.
But I'm happy to propose as set out. I think it's very sensible to refuse this application.
That is a proposal for refusal set out. Is that seconded?
I'm happy to second that.
Is there any debate? As there is no debate, we'll move straight to the vote, and I shall vote. It is proposed and seconded for refusal as set out. All those in favour, please show. That is unanimous. Thank you very much.
I'm happy to second that.